Welcome back on the AM show. And just to clear my throat, I just had a sip of water. And guess what? It was awake purified drinking water. It is treated through a strict purification process to ensure that every bottle on the market refreshes you better. And for those who want different sizes, maybe for your kids going to school, for you, something to fit in your bag, or if you want something bigger to last you an entire day, they have you covered. 330 and 500 ml bottles, 750 ml for those who want more, and 1.5 liters for those who are heavy drinkers. So there's no excuse now. You're fully covered. Just reach out for a bottle of awake purified drinking water. If you're thinking of something for your homes or offices, you can also use the 19-liter jar bottles. Now choose a bottle of awake purified drinking water and get quality hydration. It's another quality product by Casapreco Company Limited. But here's a very heartwarming aspect of all of this. For every bottle you purchase, an amount, a token, a donation is made to the National Cardiothoracic Center. So the more you buy, the more you contribute to the kitty of the National Cardiothoracic Center. And that is indeed heartwarming. If you'd like to purchase in bulk, call this number 0262 351 251 0262 351 251. This advert is FDA approved. And this conversation we're about to have next is sanctioned by all of you. We know. You want to get down to the bottom of what former President John Dramani Mahama has been saying, that he will review, clarify the constitutional provision that prevents Ghanaians who hold dual citizenship from actually holding public office. But what is your take on that? Well, we've heard from a number of prominent people on that all-important matter. And this morning we get into the conversation with our guests, starting with Dr. Arthur Kennedy. He is domiciled in the United States, very Ghanaian, a member of the MPP, as he confirmed the last time I spoke to him. Some people had said, no, he's not even a member, but he says, I am a member. Doc, a very good morning to you. Thank you so much for welcoming us into your home. Can you hear me, Doc? Please, you'd have to unmute, Doc.
Hello?
Great, I can hear you now. Now
Hello?
We're back. Thank you so much. So
Good morning to you and all your listeners.
It's good to have you. Now, this conversation we're going to have, of course, I had an interaction early on, and it was with former flag bearer of the PPP, the Progressive People's Party, Bridget Jogbanuku, and she said to me, look, in terms of the dynamics, someone has lived his or her life abroad, but the person is fully Ghanaian, or even if the person decides, okay, in my endeavor outside, I have become a citizen of some other country, whether Western, Eastern, or African, but I still retain my Ghanaian citizenship. So I have dual citizenship and I want to serve Mother Ghana. That person is barred from doing so until that person relinquishes the other citizenship. I saw it come to play when recently Nigeria elected a new president, Tinubu. Some questioned the fact that he had been given honorary citizenship by, I think it is Guinea, and some, people went to the streets on that. Of course, there are different dynamics to look at. Is it a problem to have dual citizenship and want to serve? And for you, what are the different dynamics that come to play?
Well, it should not be a problem as far as I'm concerned. People or citizens of a country living in the diaspora and participating in the affairs of that country is as ancient as history. I mean, it goes all the way to Jesus Christ, who was a diasporan. Joseph was a diasporan when he helped his brothers. When he came to Ghana, we talk famously about the case of Nkrumah and many others. And in actual fact, I am told that the founder of the Ashanti nation, Osei Tutu, was an Ashanti diasporan who lived in Akwamu, who returned with his experiences to found his country. On behalf of diasporans, I can tell my fellow Ghanaians that those of us who live outside are fully Ghanaians, not even because we were born in Ghana's geographical space, but because I assert fully that Ghana was born in us. I think that it is something we ought to cherish, that people who were born Ghanaian and have lived elsewhere still want to participate in our affairs. I think that we bring a lot of wealth. You know, when you look at 2021 figures, Ghanaians in the diaspora contributed 4.2 billion to our economy. That is a little over 6% of our GDP. It's not even just the contribution. We bring a lot of talent. And in actual fact, it is the same logic that makes Ghanaians want diasporans participate in the national team, the Black Stars, because they know instinctively that it makes us better when we can gather Ghanaians from all around the world. So I actually think that President John Mahama's pronouncements are very welcome. Of course, when we say that we ought to welcome or acknowledge the signal contributions of the John Agyekum Kufuor government, which passed ROPAL in 2006, and it is a disgrace that we still have not implemented it. In actual fact, ROPAL might be a more signal step than even the dual citizenship we are talking about. And the dual citizenship has a bill in front of Parliament, which a lot of people have contributed. So President Mahama's pronouncement is right on point, and I think it should be commended. And the MPP, in its tradition of helping to advance the frontiers of our democracy, should go back and do what it needs to do and join it. And by the way, we always brag about being the torchbearers of Africans. This time, we are not even leading, apart from, of course, the examples of US and Canada doing that. Even in Africa, Nigeria, Senegal, South Africa, Cape Verde, all allowed their citizenship in the diaspora to vote, and nothing untoward has happened. Indeed, Senegal has representatives to its parliament from the diaspora.
Interesting initial thoughts you have shared on this matter. Of course, there have been different dynamics even before we get into what the law says and what this amendment seeks to achieve. There are also those on the other side. You have spoken about the positives of dual citizenship, but how about the other side? Some have said, for example, that in countries where, and every country exercises counterintelligence or counter-espionage, you would try to impede other countries. And every country, looking at their representations in other countries, would want to gather information on those countries, sometimes information that doesn't inure to the benefit of the host country. And that is why when they are found out, then they would, these diplomats would be declared persona non grata, and they would have to leave sometimes in some instances. Some have suggested that we put our national integrity, allegiance at risk if we allow people who have divided citizenship, or so to speak, divided allegiance. What do you make of that?
Respectfully, that is a red herring. My brother, most of those who have destroyed Ghana have been people who didn't have dual citizenship. The people who are running our country into the ground for the most part are full citizens. So I really do not think the mere possession of a second citizenship would dilute anybody's loyalty. We know that, there are people who live in the diaspora here. At the mention of Banku or Fufu, they start salivating. They dream about Ghana all the time. And if you think about it, after all the progress that you've made and how well you are paid elsewhere, why would you care about Ghana if it was not for the love of the place? As they say in Akan, that is where your umbilical cord is. So actually, the people here should worry more about our legends than Ghanaians should. And it's ironic that from time immemorial, Ghanaian governments have always been willing to offer citizenship to Black Americans and other Blacks in the diaspora. without worrying about their loyalties. You know, they say, oh, you are African, so come home. And yet those of us who actually
We've had the
come
year of
from Africa
return,
want to
beyond the
come
year
home.
of return as well. And,
Yeah,
and we are not willing to welcome our own back home.
absolutely. Absolutely. So I really think that is a red herring. I think that those artificial doubts are constructed by people who see holding office as quote unquote sharing the spoils as compared to putting the best team on the field. And I think we ought to be looking to put our best team on the field, regardless of where they live. And it is very commendable that people spread all around the world should care so much about Ghana. We should not be doubtful at all about the loyalty of those in the diaspora. They are some of the most loyal Ghanaians I've ever come across.
Let's look at this latest amendment and what it seeks to achieve. First off, and I'll find some of those segments so we can take a critical look at them. But we know the Council of State has unanimously approved the Constitutional Amendment Bill to repeal both Articles 8.2 and 94.2a. The next stage is for Parliament to vote on the bill. And of course, we have ex-President Mahama suggesting he is in full support of that bill. Earlier, I was interacting, like I said, with Bridget Jogbanuku, and the relevance of some of these over time. You look at 1960, for example, and the Criminal Code or the Act 29, and some 63 years on, their relevance to our national life, to our aspirations as a people. When you look at the 1992 Constitution, it talks about the aspirations of the people. Some people have even questioned some aspects of our current Constitution on the back of relevance 30 plus years on. For you, from the legal standpoint, do you think this has now become redundant and deserves to be not maybe removed, but reconfigured to suit the times?
It should be removed pell-mell, without doubt, without hesitation, and full speed. You know, it is the equivalent of being in the ring of development with our hands tied behind our backs. We need to make the rich talent pool in the diaspora, the rich financial resources fully accessible to our development by showing in wealth and in deed that we fully embrace our talent spread around the diaspora.
Let's look at what the 1992 Constitution says about dual citizenship. It's in section 8, and I'll just read. I will go to 2, but I just want to read the premise in 1. It says, subject to this article, a citizen of Ghana shall cease forthwith to be a citizen of Ghana if, on attaining the age of 21 years, he, and of course he here is generic, by a voluntary act other than marriage, acquires or retains the citizenship of a country other than Ghana. 2. A person who becomes a citizen of Ghana by registration and immediately after the day on which he becomes a citizen of Ghana is also a citizen of some other country shall cease to be a citizen of Ghana unless he has renounced his citizenship of that other country, taken an oath of allegiance specified in the second schedule to this constitution, and made and registered such declaration of his intentions concerning residence as may be prescribed by law, or unless he has obtained an extension of time for taking those steps and the extended period has not expired. When we go to 94.2, which is what I'm going to skip to, and then just add what that says so we can situate this properly. Yes, I am almost there. Where are you? 94. 94. There it is. All right. So when you go to 94.2a, 2A, it says, let me start again from 1. I'm doing this for the sake of education, for those who may be watching us who probably haven't accessed the Constitution, though it is everywhere online as well. In terms of qualifications and eligibility, 94.1 says, subject to the provisions of this article, a person shall not be qualified to be a member of parliament unless A, he is a citizen of Ghana, has attained the age of 21 years and is a registered voter. B, he is resident in the constituency for which he stands as a candidate for election to parliament or has resided there for a total period of not less than 5 years out of the 10 years immediately preceding the election for which he stands, or he hails from the constituency. And C, he has paid all his taxes and made arrangements satisfactory to the appropriate authority for the payment of his taxes. But 2A is the most relevant here. 94.2A. A person shall not be qualified to be a member of parliament if he, A, owes allegiance to a country other than Ghana. And then, of course, we have B, has been adjudged or otherwise declared bankrupt, is of unsound mind, has been convicted before, and then it goes on and on. Having seen the letter of the law, I'll come back to you. Must the spirit of the law change in this regard in terms of what we have? Some say what we have is apt. Do you disagree?
Strongly. I disagree vigorously. You know, I think that in actual fact, the qualifications for parliament has the seeds of what we should have been heading for when, as one of the criteria, it says hails from the area. I think we should make it the same way for holding national office. Those who hail from Ghana ought to be qualified, and that ought to be the end of the story. I think that there is a lot of tea leaf reading between loyalty and oath, and actually we end up indirectly creating two tiers between Ghanaians abroad. For example, somebody acquired foreign citizen by virtue of marriage, and somebody also did it away. They are both foreign citizens, but one of them can then hold office because we do not doubt their loyalty, but the other person we doubt their loyalty. This is insane. You know, I think the essence of the thing is that Ghana beats in our heart, like I said. It's not even that we're born in Ghana. Ghana was born in us. You know, wherever you go to a gathering anywhere and there are Ghanaians, sooner or later, the talk turns to the part of our country, and everybody there is passionately trying to find out ways in which we can uplift our country. And a lot of people don't understand that after you live here, there are rights that you acquire here in terms of the property, in terms of taxation and other things that you shouldn't just get up and give up. You know, the benefits of retirement and all that kind of thing. And if you even suddenly got up to leave and go to Ghana, there are problems with how much taxes you pay. And the question is, why is it that if I have a Black American neighbor, my government will be lobbying him and laying the red carpet for him to become a Ghanaian citizen while it is telling me I am disloyal? It just doesn't make sense.
Let me bring in Professor Kweku Asare, who also joins the conversation. Prof, thank you so much for joining the conversation. I have kept you unwittingly waiting. Thank you so much, sir.
Thank you and good morning.
It's a great pleasure.
To, my friend and brother Atta Kennedy as well.
It's a great pleasure having you.
Good morning.
Usually I would see you watching us have our conversations online. Today you're joining us. So, Prof, thank you for doing us the honors. I'm sure I don't have to repeat myself. You followed the conversation. We've spoken about the what ifs. We've spoken about what the Constitution says, the letter of it. What is your position on this? Ghanaians out there doing great things, but maybe with citizenship that is, you know, with dual citizenship. Let me just leave it that way. They have citizenship of other nations and they also have Ghanaian citizenship. Why do we bar them from public service? But on the other front, some will talk about allegiance. Some will talk about the fact that you could have divided interest, which could be dangerous to our collective good. What is your stance on this matter?
Well, I'm glad indeed that you read Article 8, and then you also read Article 94 2A, because they are different and they relate to different things. Unfortunately, they have not always been read correctly.
Okay.
And it is interesting that the Article 8.2 and Article 8 that you read were actually the old provisions from the old unamended constitution that actually barred dual citizenship. Dual citizenship was not allowed under the regime that you read from. Once you understand that old Article 8.2 did not even allow dual citizenship, then you would also understand that Article 94 2A has nothing to do with dual citizenship or a status that was banned to start with. Now, these divided loyalties and so on that you were talking about were some of the reasons given for the bar in the old constitution, in the unamended Article 8. However, in 1996, we presented a case to the then parliament and provided evidence that the fears that they had, divided loyalties and so on, were all needless. And indeed, if you go back to the roots of Ghana history, we all started as British subjects until May 1957, when the First Nationality Act was enacted. And it was convincing. And so in 1996, Article 8 was amended to allow for dual citizenship. Now, Article 8 to itself provides some limitation on dual citizens. There are some offices that dual citizens are not allowed to hold under Article 8.2. But those limitations are quite different from the burden imposed by Article 94 2A, when Article 94 2A talks about allegiance. Let me explain the allegiance in Article 94 2A. It has nothing to do with dual citizenship. It actually has to do with single citizens who are engaged in what the then Constitution, if you go back to the 1969 Constitution and the 1979 Constitution, and you seek to understand what allegiance means, it refers to holding an incompatible occupation. For instance, a Ghanaian who is also a spy for a foreign country. And it was interesting at the time because of some of the things that were going on. Some people are old enough to remember the swap of Susudis and about 8 Ghanaians who were deemed to be working for the CIA and against the interests of Ghana.
And just a quick point on that you make, because that's a story I have heard, the swap of is it Mark Zudis tied to the former President Rawlings for a number of other foreign nationals. Interesting point you make, but there's a premise to all of this, isn't it? Because if you go back to the coup that ousted Nkrumah and the so-called instruments that were used, weaponized against him by the CIA and all of that, there is a great checkered history as far as this is concerned, which also stokes the sort of conversation around being solely Ghanaian, isn't there?
Yeah, I mean, even Nkrumah himself weaponized this to some extent, because you see that members of the Muslim Youth Association, Amadou Babal, Otto Ladan, and so on, they were big Ghanaians, but they were deported on these same grounds. And by the way, what you are talking about is not unique to Ghana. If you go to a place like Zambia, whose Kwame Nkrumah is Kenneth Kaunda, there was a point in time in their history, I think in 1996, where Kenneth Kaunda was disqualified because apparently his father was deemed to be from Malawi. Now, of course, there's court later on tended, but we've had the same problems in Ivory Coast, we've had the same problems in Nigeria and so on. But all of these countries have come around and they have understood that in an inclusive society, you're not going to be able to restrict some members of your citizens from fully participating in the public space. But the important point I was making is that all the prosecutions that are brought under Article 94(2)(a) against Ghanaians who have dual citizenship are improperly brought because Article 94(2)(a) has nothing to do with dual citizenship. Rather, it is Article 8 and Article 8(2) that talks about the burdens of dual citizenship. So when you talk about Adamu Sakede, when you talk about Jechi Kwesin, when you talk about Akwesi Agyeman, when you talk about Charles Edubuahin, when you talk about Mona Quartey, all of these people were disqualified under Article 94(2)(a), not because they owe allegiance to a country other than Ghana, but because they are dual citizens, which they couldn't be because dual citizenship is addressed in Article 8(2). Now,
but still, 94(2)(a) addresses that. In fact, the premise for 94(2)(a), it states a person shall not be qualified to be a member of parliament if he, the first one, A, owes allegiance to a country other than Ghana, before it goes on to the other points.
Now, that's what I'm saying. Don't read it literally, because it doesn't mean dual citizenship.
Okay.
There's a principle in law called meaningful variation. If there's Article 8(2) that talks about dual citizenship, and there's Article 94(2)(a) that talks about allegiance to a country other than Ghana, it cannot be the case that they are all talking about the same thing. Law is not made that way. Every change of word has a meaning. There is a reason why there is this allegiance clause, and I've explained to you that the allegiance clause cannot even sensibly relate to dual citizens because originally dual citizenship was not even allowed.
Okay, so
how can Article 94(2)(a) be directed to a status that was not even allowed?
Okay.
It is important that we read the Constitution carefully. Now, I accept that it has been, misinterpreted, and I agree with all those who are now calling for, look, regardless of whether it's Article 94(2)(a), which has been misinterpreted, or the limitations. There are limitations also imposed by Article 8(2). For instance, one cannot even belong to the Supreme Court if he's a dual citizen. That is also important that we remove that, because you cannot have a nation whose apex court excludes some of the citizens from even being eligible to sit on it. That does not happen anywhere in the world. Being a judge is a technocratic position. Do you know the law? Do you apply it fairly? And so on. Why is it that somebody who is a dual citizen cannot be a Supreme Court judge? And there are other limitations. For instance, even a position like special prosecutor, not under the Constitution, but under the Special Prosecutor Act. The special prosecutor, a person who owes allegiance to a country other than Ghana, cannot be a special prosecutor. A person who is a dual citizen or who owes allegiance to a country other than Ghana cannot even sit on the Lands Commission of a particular region and the National Lands Commission. So let's look at this. You could be, in theory, the Omahene of an area, but if you are a dual citizen, and a dual citizen can be an Omahene, if you are a dual citizen, you can be an Omahene, but you are disqualified from sitting on the Lands Commission in your own region. What are we doing to ourselves? What are we doing to ourselves? And the second and important point is, here we have a natural experiment, because we had some fears about dual citizens, and we barred them from actually being Ghanaians. We excluded them completely. If you become a dual citizen, you are no longer a Ghanaian. Then after 1996, we found out that, look, this is not good enough, so let's change it. After we've changed it, it's almost 30 years since we changed it. And all the fears that we had about their being divided, about this, about that, none of those fears have materialized. So 30 years after, we should be in a position to revise our beliefs.
In fact, Dr. Kennedy just said that those who are messing our country up, so to speak, are those without dual citizenship. They have held on to power since, let's say, the Fourth Republic, and it is not those with dual citizenship who are ruining our country.
Yeah, I mean, testing whether you are a dual citizen or a single citizen and so on, that has nothing to do with anything. The important thing, as the Nigeria court have said, as the Celerion court have said, is that were you born a Ghanaian, were you born a Nigerian in their case, were you born a Celerionian? If you are born a Ghanaian, then you are born with certain inalienable rights that cannot be taken away from you. And the most important right is the right to vote and the right to be voted for. To me, it makes no sense to call someone a citizen if you don't even trust him to sit in your parliament, if you don't trust him to sit on your Supreme Court, if you don't trust him to be a member of the executive. You cannot be a minister, you cannot be a deputy minister. If you can't trust them to sit on the constitutional commissions, for instance, a person who owes allegiance to a country other than Ghana, poorly interpreted, cannot sit on the Electoral Commission, cannot sit on the NCCE, cannot sit on the Public Service Commission. These are very technocratic positions. Why do we exclude our own citizens who are educated by our own taxpayers only to allow the IMF and other countries to send foreigners to supervise our banking institutions? I mean, I just don't even understand the logic that we can trust the IMF to send a supervisor to supervise our banks, to allow them into the inner conversations of our economic policies and economic systems. But somebody who was born a Ghanaian, raised by taxpayers' money, has traveled to acquire skills. We cannot allow them to participate on the notion that we fear that they have divided loyalties.
Right.
If anybody should fear that they have divided loyalties, it should be the country that they migrated to.
Okay.
Not the country of their birth.
I have these thoughts. Dr. Kennedy, I'll be coming to you shortly. I just want to wrap on some thoughts I have with Prof on this very beat. I don't want to lose my train of thought. So when you look at 94.2a, what then? So I'm putting two together, and this is for you, Prof, right before I go back to Dr. Arthur Kennedy. What then does owes allegiance to properly so-called mean? Have we created a nebulous clause over time? What has it meant? What should it mean? And then how then would you address what some people prefer to call honorary citizenship? Go back to, and what comes to mind, Sekou Touré and Kwame Nkrumah, when the Guinean president invited Kwame Nkrumah to his country post the coup in 1966, and then even sort of suggested that he could be co-president with him. In that shell, what then do we make of honorary citizenship as well? What rights do we give? The Constitution has a view, but how then do we look at that in this context?
Yeah, so 94.2a, as I said, should be read in conjunction with the constitutional or legislative history.
Right.
Anytime we read the Constitution, we don't go back to ask, well, why do they have this clause? If you go back and the proceedings of the 1969 Constitution are there, this is where they took this clause from. There, the explanation that they gave was that they did not want to allow people who were in incompatible occupations. That's what owe allegiance to a country other than Ghana mean, incompatible occupations. So the notion of dual citizenship is completely not anticipated by 94.2.
Since you've clearly read that, what would incompatible occupations then essentially mean?
For instance, I gave you the example of subsidy, somebody working for for a foreign agency who is maybe spying against Ghana. And even in such a situation, it was expected that the person would be tried and actually found guilty of whatever it is that we are accusing him of before we deprive him of the right, the very basic right of citizenship. It has nothing to do with dual citizenship. Second, honorary citizenship is not something that is addressed in the Constitution, but I get your bigger point that even in places like Gambia, where Nkrumah went, Guinea, in places like Guinea, if they allowed Nkrumah, who is a Ghanaian, to become a co-president without worrying about his not being a natural-born Guinean, and this was in the 1960s. How come 60 years since then, we are now quibbling about whether a natural-born Ghanaian raised in Ghana, paid his education paid for by Ghanaians, cannot participate fully in our political space? I seem not to understand the logic that somebody who is a professional, when you are a professional, if I'm hired to sit on the Supreme Court of Ghana, I'm a professional. If I'm hired to sit on the Supreme Court of Gambia, which many Ghanaian justices have sat on the Supreme Court of Gambia before, it doesn't matter whether you are even a Gambian or a Ghanaian. Right. You are a professional, and your professionalism will trump any primitive allegiance that you have to anybody. I mean, the argument makes as much sense as saying if you appoint somebody who is not a Ghana to be the Greater Accra Regional Commissioner, or if you appoint somebody who is not from the Eastern Region to be the Eastern Regional Minister, he's going to go and destroy Eastern Region because he doesn't owe allegiance to the East. I mean, it makes no sense. We are talking about professionals. All professionals swear an oath of allegiance. And by the way, when we say the president has to swear an oath of allegiance, it has nothing to do with citizenship. It has something to do with fidelity to the work that he's going to do. Right. You swear the oath of allegiance because you are promising to the people that in this job that you are going to do, you are going to abide by the Constitution and so on and so forth. It will be silly to say that when somebody swears the oath of allegiance, because you've seen the word allegiance, then it means he's going to swear the oath of citizenship. No, allegiance is a term of art. It has a meaning in our Constitution, and I hope one day the judges will actually sit down and look at the constitutional history and interpret Article 94(2)(a) correctly. But of course,
the context that you're mentioning is crucial. It is important because it's revealing what you've just said. But are you then suggesting, just to cap it off, are you then just suggesting that we've been maybe misreading and even further misapplying what the law says as far as the judicial system or the justicial system is concerned?
Absolutely. And I've been saying this for 20 years. I just did not say it today. I said it when they wanted to disqualify Akwesi Agyeman, my friend Akwesi, from being the Ashanti regional minister. I said it when they tried Adamu Sankedi. I said it when they applied it to Monacote. I said it when they applied it to Charles Edubuahin. Recently, I've said it when they were applying it to Jackie Kwesi. I'm very consistent in terms of saying, look, when it comes to the Constitution, and when it comes to disenfranchising somebody, when it comes to saying somebody, we are not going to allow you to participate fully in the political space, let us be sure we understand that the law indeed applies to them. It will be unthinkable for somebody to write a constitution that says over 1 million people, because there are about 1 million dual citizens, maybe more, 1 million people are fractional citizens, and they cannot sit even in their own parliament. I don't think any lawmaker in today's world, even as at 1992, would have come to that. And last point, there is actually an interesting case in Ghana. It's Bilson versus Attorney General. And in that case, Bilson actually sues because he wanted President Rawlings to be disqualified on grounds that President Rawlings was a citizen of the United Kingdom. President Rawlings, in his affidavit, actually says, yes, I'm a citizen of United Kingdom because I was born in 1949, and in 1949, every Ghanaian was a subject or a protected person of the United Kingdom of Ghana, of the United Kingdom. And the judge said, well, look, I'm not even going to get into this question of whether he's a citizen of another country. The important point is whether he owes allegiance to Ghana. And on that, I know because as a military officer and then as a former head of state, he has taken multiple oaths of allegiance to Ghana. And that to me is enough. So even that judge made that distinction between allegiance and citizenship. But we are just not even reading our case law properly.
Interesting, very interesting points you have made, Prof. But let me come to Dr. Kennedy. First off, do you have any reactions to what Prof has said before I come to you with a substantive question?
No, we have always been d'accord on this issue. We think that we should bring more of our talent there in our development, just like we do in soccer. And actually, to buttress his point, Ghanaians have served on the Supreme Courts of Gambia and I think Kenya, as well as I think Antigua. They've held very significant positions. So I agree completely. And actually, I think that all those who have been ginning up this argument about disloyalty and others, it comes from the idea that people see those in the diaspora not as teammates or people with talent to be invited to help our development, but as competition for the spoils of office. They see office not as a place where you go to serve, but as a place where you go and get rewards. So they see diasporan talent as competition.
Have we then done a disservice to ourselves all these years? I mean, and what is the immediacy required in terms of dealing with the situation? The Council of State has done its work. Parliament is now going to sit and look at this. It's interesting because a member of Parliament, not the first, but a member of Parliament, and there was the member of Parliament as well, Toffee, who also got into a scrape on the back of citizenship, Ivorian citizenship, I guess. She has scaled that hurdle. But James Jachikwason, the member of Parliament for Asin North, has been barred from holding himself out as a member of Parliament, elected by the people. But he can't represent the people per what the court has ruled as of now. How much of a disservice have we done to ourselves on the back of this? And now that we are moving forward in terms of Parliament, what would be your expectations in terms of the speed with which we deal with this?
Yes, we have done ourselves a lot of disservice. I think that Parliament should go ahead and do the natural thing that should have been done. I think we waited too long. I think this bill should pass, and we should commend people like Professor Asare, Lawyer Jenim Boateng, Kofi Boateng, and even the current speaker, who have all done very good work on this. But this should not be done in isolation. The law should be passed. I think RUPAL should be implemented. I think that RUPAL, in a certain sense, is even more fundamental than the dual citizen bill, but both of them work together. And third, we should also move to make sure that people with professional qualifications trying to come back to Ghana, whether they are medical professionals who have lived abroad and are clearly qualified and they are being made to jump through hoops, or legal professionals and others, we should make it easier for them to bring their talent to bear on our development. And if we do that, we can benefit, because I can tell you that a lot of those who have messed up this country had nothing to do with dual citizenship. They were full-blown Ghanaian citizens, and they have looted our country dry. They didn't feel any loyalty to that. So we need to stop looking at the wrong things and focus on looking at talent in the modern world, as well as the resources that the diasporans can bring to bear. And there is evidence. You can look at Nkrumah, for example, and the dedication with which he led us. Even a lot of our very outstanding, technical people, courts and other things. So these disqualifications, I think, never had logic on their side, and they don't do that now, and we should move as quickly as possible. So I actually think that President Mahama's remarks are very welcome. I think he should use his considerable political clout to help push the bill that is in front of Parliament across the line. I think that the MPP should not turn this into a partisan thing. They've always led the fight to expand the frontiers of democracy. That is why Donna Kufuor's government brought us through power. They should help us implement the bill and make it easier for Ghanaian professionals to bring their talent to help in our development.
But there is a political chess game being played, and if you don't play it well, you could get checkmated if you don't play it well. On that political chessboard, we have a certain James Jachikwason, who cannot hold himself out as Member of Parliament for Asin North. Now, there are different dynamics at play. The MPP could, in this tenure, back this, depending on how Parliament receives it from both ends, and now the former president, Mahama, has said he's given his blessing to this. So you would want to assume that, let's say the minority tags along. How about the majority? How will they look at the issue? I mean, even before the former president, if he gets the nod to be president again, even before that happens, this could have been cleared, which was why I was speaking about immediacy. But the reality too is, the MPP has benefited from this position, which we have currently, by sidelining James Jachikwason. If we go through with this, what it means then is that, per my reasoning, and Prof could clarify, James Jachikwason would have to be reinstated. That would not favor the MPP in Parliament. How do you address that, Dr. Kennedy? Unfortunately, the connection to Dr. Kennedy is patchy now. We'll try to get the connection better and see how it works. Doc, can you hear me now?
Yes, I can.
Did you get the question?
I missed the end of it. You were talking about Mr. Kwason and his situation.
Yes. So I was saying that the MPP administration, the members of parliament, could tag along with the NDC members of parliament, because after all, the former president has said this. So you would expect that the members of parliament on the NDC side would tag along. But how about the majority MPs? And they benefited from the system as it is, with the sidelining of James Jachikwason. He's not to hold himself out as a member of parliament. He can't perform his functions. If they go along with this, and if this bill becomes, if it reflects in the law, what it means then is that James Jachikwason has to be reinstated, more or less. It wouldn't work in favor of the MPP in Parliament, would it?
But I think I get the gist of it. I think, though, that we should not do short-termism. We should look at the long-term interests of the country. I actually think that Mr. Kwason's disqualification is one that should make every Ghanaian ashamed. The gentleman picked up forms. Somebody actually challenged his right to contest. The Electoral Commission was brought in to look at the issue. They, at that time, said that he had produced all the documents he needed to produce and that he was qualified to contest. He went ahead to contest and to win. So to go back and say that he was not qualified to hold office is really a stretch of the law, and I think that that was an injustice. But having said that, that is even picking tea leaves. I am looking at the broader situation of all these diasporan issues. Let us not do tit for tat, and these people did that, and Adam Sakande did this. I think there is too much of a spirit of vengeance. You got my guy, so I'll get your guy, and next time I will also get, we need to stop that and look forward and look to the interest of Ghana. I think that all those who are talented and have the interest. There are people here who are paid a lot for the work that they do. I tell people that and they are surprised that, I'm a physician, one of many here, but I get paid better than United States Senator. So when people who work here and are in these professions care enough about Ghana to come back and serve, we ought to be welcoming them. We should not be putting obstacles in their way. So I commend Mahama, I commend President Kufuor for ROPAL. I think we should come together and implement ROPAL. We should pass this bill, and we should go ahead to remove the professional obstacles that lie in the way of Ghanaians of talent abroad who want to come back and give to our country.
You spoke about the inadequacy or how dangerous it is. What happened in the Jachikweisa and, of course, other similar cases, I should say. If that was injustice, or if it was as bad, then how would you reference the justicial system that meted out those judgments, so to speak? What then would you say?
I think that judges and judicial systems live in the context of their societies. So by and large, that is why, for example, in the United States, there were rulings like, Dred Scott and Plessy versus Ferguson, because the courts at the time reflected the society's sentiments. In the same way, I think that
maybe even Roe versus Wade, which has now been overturned in different ways.
Precisely. So the political biases eventually seep into our judicial rulings. So I think that we need to look forward. I think that sometimes our courts can lead us forward, and maybe too often they don't do that. Ironically, I think that under the first term of Rawlings and the second term of Rawlings, our Supreme Court was very vigorous and visionary. They were forward-looking. They were very independent. I don't know what happened to them over the last few years, but I think they need to return to looking at high legal principles and the national interest rather than the interests of parties and their lobbying, because there are a lot of people who feel that Mr. Kwesi probably might not have been disqualified if the NDC were in power.
Right.
And that is really an indictment of our judicial system.
That's a very important point you just made at the end. The judicial system and political influence. In fact, political party influence. But just hold for me, Dr. Kennedy. Let me bring Professor Kukwasari back into the conversation. What would be your take on this political chess game that I have suggested could play out if this sees the light of day, if it becomes law even before the end of this administration's tenure? That would logically, unless you disagree, mean that James Jachikweisa should be reinstated. And that, from what we've seen, whether it's voting on the e-levy or voting on the budgets that we've had and all of that, that could be problematic for the MPP. What's your reading of the situation, Prof?
No, I don't read it that way at all, because.
But is that a reality? Is that, I mean, if
no,
we side with this, logically, would James Kwesi have to be reinstated?
This law, when it passes, will not be applied.
So it will not be retrospective?
Second,
are you saying it would not be applied retrospectively, and so it would not apply to James Jachikweisa?
Yes. Not only that, but his case is probably going to be resolved on May 17th, because the Supreme Court has set May 17th as the date that it gives judgment. And it will be the first time that the Supreme Court will actually be interpreting the meaning of Article 94(2)A. And that's some of the problems with our judicial system that Dr. Kennedy was describing, because here we are, we've been disqualifying people for this long, and for the first time, the person who disqualified or sought to disqualify Kwesi, after he had successfully done that, has now gone to the court and said, well, court, I'm not even sure what the meaning of Article 94(2) is, so interpret it for us. So that's the problem. Hey, let us remember
Before you go on, the May 17 ruling that you speak of, how important do you think that will be in this context and maybe even beyond? How important will it be?
I think Parliament can do whatever it wants to do, irrespective of what the court decides on May 17th. So what is going to happen on May 17th is interesting. It may moot some of these issues if, for instance, the court properly decides that Article 8.2 and Article 94.2 do not mean the same thing. I don't know how the court can say they mean the same thing, because then why do we even have two articles? And in the case of Chikwueze, let us remember that whether it is Article 94.2 or Article 8.2, he's not affected because he is a person who has renounced his Canadian citizenship. He is not a dual citizen, and he doesn't owe allegiance to a country other than Ghana under Article 94.2. So I'm not sure that his case is the proper case for us to be talking about this.
The question was that he, at the time of applying, he hadn't renounced his Canadian citizenship.
But the Constitution does not say that. The Constitution does not say that at the time, when you read Article 94.2, it did not say that a person who applies to run in a general election. It says a person who is an MP. So the test is at the time of entering Parliament. At the time of entering Parliament, you owe allegiance to a country other than Ghana, even if we assume that allegiance meant dual citizenship. That's how we should interpret it. And in this case, he had applied to renounce his citizenship in 2019. We cannot hold any delays by Canadian bureaucrats against him. I mean, how is it that we can say to someone, you continue to be a Canadian citizen, even though you've moved away from Canada, you've given them your passport, you've applied to renounce everything, and I mean, we are disqualifying you because the Canadian bureaucrats have not said that. And if you go and you read Canadian law, I've given examples on the web on a presentation that I gave before. How do you renounce Canadian allegiance to Canada? Basically by going outside and saying, I've renounced my allegiance. That's it.
Yeah.
Because they distinguish between citizenship and allegiance. And renouncing allegiance is not a formal process. It's just a question of what you yourself say. If in your mind you don't owe allegiance to Canada, fine. They can't interrogate your mind. Now, citizenship is a different thing because it's a status that is conferred by Canada, and they can either give you citizenship or take your citizenship away from you. But they can't compel you to owe allegiance to them. So there are many people who say they don't owe allegiance to Canada, including single citizen Canadians, because of their link to the King of England. So that is the point. This issue, by the way, is a bipartisan issue. You can see that I've cited people who have suffered under NPP, and I've cited people who have suffered under NDC. Yeah. So it doesn't wear any political color, and so we must view it at that. I'm glad His Excellency, the former president, mentioned that he sides with the bill and is interested in the concept, in the substance. He substantively agrees with what it is that the bill is seeking to do. And we must not forget, if you go back to July 2019, the current president himself also said that he's interested in bringing a bill to Parliament that will allow dual citizens to hold public office. So there's bipartisan support for the bill. The president supports it, ex-president supports it, NDC people have suffered, NPP people have suffered. It is not in the interest of Ghana. We must set aside our personal interest and so on and come together and finish the job that was started in 1996 when we allowed Ghanaians to hold dual citizenship. You cannot, by law, say we are going to allow you to be a dual citizen, and then by the same law say, well, but as a dual citizen, you cannot be in the executive, you cannot be in the parliament, you cannot be in the judiciary, you cannot serve on the Constitutional Commission. That is not citizenship. Citizenship is defined as the rights that you have. The difference between a Ghanaian citizen and a non-Ghanaian citizen is that a Ghanaian citizen can participate fully in the political space. As soon as restrictions are put on you with regard to your participation in the political space, then some of your Ghanaianness have been chipped away.
Right.
Now, final point, let's go to United Kingdom. You know, you don't even have to be a UK citizen to sit in the Parliament of England. If you are a citizen of the Commonwealth, that means if you are a Ghanaian citizen, as an example, and you are permanently resident in the UK, you can run for Parliament. And that's what our constitution used to be in the 1957 constitution. When you read it, our parliament could be occupied by any citizen of the Commonwealth. If you look at people like Geoffrey Byng, who was the first Attorney General, he was from Scotland. If you look at Speaker Akiwumi, he was then, of course, Gold Coast, but also he was also a Nigerian, and so on. So we have gone away from our heritage, and we have introduced too much pettiness into our politics. And as I said, the pettiness of exclusion. Anytime you are excluding people, you are denying yourself of the benefits of inclusion. And so I'm going to conclude on 4 key grounds. Number 1, for liberty, from a liberty point of view, we must include all our citizens. Number 2, from an economic point of view, we cannot afford to exclude those who send remittances. And if we are thinking about issuing diaspora bonds, you cannot go to the US or Canada or UK or Nigeria and say, hey, we want you guys to buy our bonds. But guess what? We don't think you are loyal enough to sit in Parliament. We don't think you are loyal enough to be the chief fire officer. It makes no sense. Number 3, we have to figure out a way to align our rhetorics with our actions. We say we are the trailblazer when it comes to Pan-Africanism. We hold the year of return. We do all these things. And then behind the door, we say, well, come home. We want you to bring all your money home. But when it comes to political participation, we don't trust you. Why would you trust their money, but not their participation in your political space? And number 4, global trends, Celerion. They didn't even do it by Parliament. Their court said, in this inclusive world, we are not going to allow a law that limits some people from fully participating in the political space. So anyone who is born a Celeronian will automatically qualify to be in Parliament. The same thing was said in Nigeria. And as I've given you other examples in UK, Canada, and so on. So global economics, and then finally the public interest. The brain trust of this country, because we are a net exporter of skilled labor, resides outside the country, and at some point in time, they all come back. When they come back, we should welcome them. Even when they are there, we should figure out a way of using their brains. For instance, the technology that we are using today allows us to use the brains of Dr. Kennedy, even though he's not physically present in Ghana. Now, if he's physically present in Ghana and he says, I want to do something, then you say, we don't trust you. Now, we are going to be able to trust Dr. Kennedy to treat our president as a physician. We don't have any questions if he has, I don't know whether he is a dual citizen or not, but if he was, we wouldn't question his allegiance and loyalty to treat the president when the president is ill. We don't have any problem flying our president and other big people outside the country to be treated by foreigners. I mean, when our lives are at stake, we trust our lives to professionals. There's a reason we trust our lives to professionals, because professionals abide by professional standards. There's no professional who is going to accept a job in Ghana and say, well, because I'm a dual citizen, I'm going to do the wrong thing. No, it's unthinkable to me that we can think that a professional will do that. That is why countries like Kenya, countries like Gambia, and so on, that is why they allow Ghanaians to go there and serve on their Supreme Court, because they value their skills, they value their knowledge, they value their experience, they value their education, they value their training. They don't care very much that they are not Ghanaians. And that is what we need to do in June to, in a bipartisan fashion, say we unanimously agree that the time has come for us to embrace all Ghanaians, whether or not they have the citizenship of another country.
Prof. It's been very enlightening today, and even talking about the context of most of our laws. That is crucial, and it's a very important point you've made ahead of May 17. Your final words, Dr. Arthur Kennedy.
Yeah, I am glad that we've come to this point in our nation's evolution. It is late, but it is better late than never.
Right.
So I commend former President. I urge Parliament to validate our journey by passing the law. But I also think that Parliament and the Electoral Commission should work to implement ROPA in 2024, because all those are parts of the puzzle. And as Prof has said, we should find ways of making sure that professionals who are returning to give us our skills can find the welcome mat. It is inconsistent for my Black American neighbor to be wooed by Ghana to become a citizen, while the same country is trying to deny me my rights as a citizen. It just doesn't make sense. And that is why a lot of African countries are leading the way. We are the trailblazers of Africa. We should follow, we should have been leading. You know, actually, Senegal has gone to the point of creating diaspora seats for its citizens abroad to represent them in parliament. And as Prof has made clear, and I have made clear, a lot of African countries do that already. South Africa, Nigeria, Cape Verde, Sierra Leone, Senegal. So we are too late to the party. We should join it and join it happily in a bipartisan, generous, positive, forward-looking spirit. I thank you for the opportunity.
And we thank you. Of course, the former president, 2 days ago, former President Mahama saying a country's human resource is its best resource. We happen to have 3 million of our citizens abroad, and then he expatiates on the need to allow these people to also serve. Well, gentlemen, we cannot but be grateful to you for joining this conversation. Dr. Kobina Arthur Kennedy, of course, joining us all the way from the United States. Doc, we're very grateful for your time. And he, by the way, is a member of the MPP. We also had Professor Kweku Asari, a D&D Fellow in Public Law and a CDD Fellow in Public Law and Justice. Prof, we're grateful for the education today.
Thank you so much. I appreciate it.
Thank you, Doc. Thank you, Prof. And do have the best of the day.